What assets will I be able to keep in a Chapter 13 bankruptcy? Attorney James Hornbuckle explains that. The incredible thing about Chapter 13 bankruptcy is that the person filing can keep everything that he or she wants to keep. It's much different than Chapter 7 bankruptcy, where there are limits to what can be protected. For example, in a Chapter 7, $100,000 of equity in a house can be protected. However, then only a certain amount of equity in a vehicle and a certain amount of money in a bank account can be protected. Anything above those limits, the Chapter 7 trustee looks at liquidating and using the proceeds to pay creditors. In a Chapter 13, for instance, if someone has $250,000 of equity in their house, all of that can be protected. The way the process works is that as long as a plan is proposed that is affordable for the person to pay back what is owed on the credit cards, then he or she is protected from any lawsuits by the credit card companies. The individual is protected against anyone selling his or her house or taking any of the property, and all of the assets are protected. What is interesting about a Chapter 13 bankruptcy is that it all depends on the person's ability to make the monthly payment. There is an analysis that has to be done in Chapter 13 bankruptcy case called the Chapter 7 liquidation analysis. In a nutshell, it means that the creditors in a Chapter 13 bankruptcy case have to do at least as well as they would do if a Chapter 7 case were to be filed. The analysis is nothing to be concerned with, which is why it is done ahead of time to make sure that the payment structure is done in the right way, so that the creditors are paid back over the 5-year time period. The reason why that is better than a private debt consolidation is that it's at 0% interest, and not all of the credit card companies may file claims. For a free case evaluation, contact the Cornerstone Law Corporation at 888-533-4384 or visit www.cornerstonelawcorp.com.